Thank you very much, Gabriella. Well, can I say what a great pleasure it is to be here. It's an enormous treat, really, for a practicing lawyer to step out from the routine of practice to think about issues which are really of fundamental importance and which, as Conor has shown, are issues that in other contexts have preoccupied me for some time. But can I first invite you to join me in imagination in the outer courtyard of Les Invalides in Paris? Because there, among the artillery pieces that are laid out for display, is a 12-pounder, and you can see this on the museum website, Le Solide, on which is engraved and cast in relief the words Ultima Ratio Regium. Now, in fact, this was cast not only on this particular canon, but on almost all of the canon of Louis XIV. Now, one can doubt, of course, whether recourse to force was ever really the last argument of Louis XIV. But I think in the context of thinking about international courts and the conventions which create them, we do well to bear in mind that historically recourse to force has been the most important way in which disputes have been resolved in the past, and that international conventions and international courts, insofar as they prevent that, and as we know they don't always prevent that, even in contemporary Europe, serve a useful purpose. Now, and at the risk of trespassing over territory covered magisterially by Lord Sumption, it's of course well known that not everything can be resolved by mere negotiation, and that international tribunals have historically served the function of bridging the gap between the space where diplomats are unable to agree, but there's a recognition that recourse to force is illegitimate. But what, however, is the role and purpose of an international court or tribunal in resolving disputes between individuals or between individuals and public authorities? And an answer to that question must, I think, first acknowledge that international courts have historically had that role from time to time, but that normally some special feature is observable when such a role is conferred on an international court that can be said to belong properly to national courts, or at least to have a function that can be carried out, or could be carried out, by national courts. And when international courts have the functions of determining disputes between individuals or between individuals and public authorities, normally there are specific problems of purpose, function, legitimacy and trust that come into play. Why, it might be asked, and indeed often has been asked, do we need this or that foreign court to decide cases that can be, that should be decided at home? The earliest surviving examples, perhaps, of international courts exercising jurisdiction over individuals are probably the Roman Rota and the Apostolic Signatura, which have, with interruptions and rejigging, existed on a stable basis since the mid-13th century as respects the Rota, and from the first half of the 15th century for the Signatura. The English, later British Privy Council, heard appeals even before the creation of the Judicial Committee of the Privy Council in the 19th century. And of course, again, and with respect to both of those courts that I've mentioned, from time to time, for reasons which it's convenient, if a little reductive to call political, states have rejected the jurisdiction of international courts. So the Ecclesiastical Appeals Act 1532, an act of the English Parliament, prohibited appeals from England to any Roman court, including the Rota, and Section 1 of the Irish Constitution, Amendment number 22 Act 1933, abolished appeals from the courts of the Irish Free State to the Privy Council. And of course, it's also worthwhile perhaps quickly to note the existence of some courts which challenge taxonomy by eluding a straightforward designation as either national or international. depending on how the Holy Roman Empire is to be classified after 1648, whether as a federation of states or as a federal state, then what are we to make of the Reichskammergericht? And we recall how various states within the empire were able to resist the jurisdiction of the Reichskammergericht through various privilegia de non appellando, and this kind of national judicial autarky became a theme in the last century and a half of that impressive polity. Well, in a sense, justifying the jurisdiction of international courts, such as the Rota or the Judicial Committee of the Privy Council, doesn't seem difficult. There is, it might be thought, an obvious requirement to have a final court of appeal to determine questions of canon law, the most enduring and widespread legal system, which can arise from anywhere in the world, and the once vast extent of the British Empire and the still far-flung nature of Crown jurisdiction make such a court as the Judicial Committee, but not necessarily the Judicial Committee, a practical constitutional necessity. And a new example, in addition to the Court of Justice of the European Union, is perhaps in the Caribbean Court of Justice, with both its appellate and original jurisdiction, and that's an example perhaps of states securing for themselves a judicial resource which might not be proportionately acquired individually. It's also an example of a new international arrangement, the Caribbean Community Single Market and Economy, providing for itself a tribunal similar to the role performed by the Court of Justice of the European Union. But when one turns to consider the European Court of Human Rights, a number of fairly basic questions begin quickly to occur. Among these are, is that court necessary in order to secure human rights for all of the citizens of the Council of Europe? And a variation, a rhetorically supercharged variation of that question is often put, is the European Convention on Human Rights all that stands between the citizens of the Council of Europe and barbarism? And of course there are those who profess to believe an affirmative answer must be given to that question, and indeed if an affirmative answer truly had to be given to that question, that would be a very powerful reason indeed to keep the Strasbourg Court, and such persons who insist on that kind of affirmative answer often accompany their yes with a question of their own along the lines of, does the United Kingdom really want to line up alongside Russia? A question to which obviously a negative answer is expected. But a better comparison, if one is truly attempting to evaluate the European Court of Human Rights, one that has been suggested recently by a Ukrainian lawyer, Daria Fedotova, is between Canada, which is not of course a member of the Council of Europe, and Turkey, which is. And she says, and I quote, "To see a real difference made by the ECHR, one has to simply compare Canada and Turkey, countries earnestly committed to protecting their citizens' rights, do so based on their own, usually centuries-old and well-developed legal traditions." And in words that might be thought to be oddly prophetic, in his preface to his book, his 2001 book, Human Rights and the End of Empire, Britain and the Genesis of the European Convention, Professor Brian Simpson observed of Russian accession to the convention system, I quote, "It is too early to judge what practical effects Russian accession to the European system will have, for Russian political culture wholly lacks that commitment to the idea of the rule of law, which is a precondition to the efficacy of that system." And the reference to the rule of law is important, because textual primacy is given to the rule of law in Article 3 of the Statute of the Council of Europe. Naturally, we spend a lot of time thinking about the European Convention on Human Rights, but we should also, I think, give due attention to the foundational constitutional instrument of the Council of Europe, it's the Statute. So there's Article 3, and the obligation to accept the principles of the rule of law and of the enjoyment by all persons within its jurisdiction of human rights and fundamental freedoms, and so on. Now, Professor Simpson tells us that during the course of drafting the Statute of the Council of Europe, there was then added an Article 8, which provided for a gentlemanly, would you like terribly to resign, would you mind terribly resigning, underpinned by the possibility of expulsion. And in his history, Professor Simpson argues that the inclusion of this Article 8 provided a strong reason for the drafting of a European Charter which would specify what the human rights and fundamental freedoms were. And that obviously became the ECHR. Now, this talk rests on two premises. The first is that reform of the European Court of Human Rights is necessary. The second is that the necessary reform of the European Court of Human Rights is possible. And of course, a state could simply denounce the Convention and leave the Council of Europe. And if the second of my premises turns out to be ill-founded, it may very well be that reform is not indeed possible, then I think the likelihood of states leaving the Convention may increase. After all, the Convention exists for the benefit of states, and if it becomes unduly burdensome and cannot be reformed, then the argument for shedding such a burden gains strength proportionately. And parenthetically, it may be thought among those who consider that reform of the Strasbourg Court is not necessary, there will be those who, while often being highly critical of judgments, individual judgments of the Strasbourg Court, consider that the encroachment of these judgments on the national sphere is negligible. And such people do have an argument, and the prize example is the final resolution of the Committee of Ministers in Hurst against the United Kingdom, passed on December the 6th, 2018. And the committee was satisfied, and it will be remembered that Hurst is the decision which said that the blanket ban on voting by persons convicted and in prison breached the Convention, but the Council of Ministers was satisfied by an arrangement which involved no change in the law, but made instead changes to the policy and guidance to the prison service to make it clear that two categories of previously disenfranchised convicted prisoners, those on temporary licence and on home detention curfew, that is, people who are released subject to a curfew but they're not actually in prison, are now able to vote. So, in summary, the committee was satisfied by an implementation proposal that has resulted in the continued ineligibility of all prisoners serving sentences, no matter how short, imposed by criminal courts from voting in parliamentary elections. So, essentially, the Committee of Ministers was satisfied with nothing, practically. But the reality is that with the exception of outliers like the approach of the Committee of Ministers in Hurst, that Strasbourg judgments have been observably effective in bringing about change in many aspects of domestic policy across Europe. Now, why then does the Strasbourg Court need to be reformed? And I should say that every year when I was attorney, so 10 years, I would have gone on a study visit to the Strasbourg Court, met the judges, met the registry staff, usually had a joint seminar on some topics of mutual interest, and it was a hugely invaluable experience. And never did I, during that time, meet a registry lawyer of the Strasbourg Court who was not an accomplished lawyer, and many of them would rightly attract the description that a former president of the court, Jean-Paul Costa, gave to a former deputy registrar, like Michael O'Boyle, mentioned earlier, remarquable juriste, and he is indeed a remarquable juriste. Now, these judges and lawyers determine two types of cases, interstate cases and those arising under Article 34, and those are by far the more important. Now, few people looking at the text of the rights contained in the first part of the Convention will, irrespective of their particular political philosophy, their place on the imaginary left-right spectrum, find much of anything that is unreasonable. Of course, there'll be drafting quibbles, that's inevitable. But it's hard to imagine, for example, 100 legal philosophers being asked to produce a human rights convention or charter without the great majority of their productions looking very much like the convention and containing the rights that the convention does. The problem, and it's a profound problem with the convention, is not the rights that it contains, it is what the court, created by the convention, does with those rights. And we know about the establishment of the court established under Article 19 of the Convention. And of course, if the Strasbourg Court might, in theory, decide that what everyone who signed the agreement understood to be X, now after the passage of time, in fact meant Z or Y. That would be less of a problem if there was no sense that the Strasbourg court would ever, as a matter of practical reality, do that. But we know, of course, that that's exactly what the Strasbourg court does. Reference has been made already to the 1978 decision of Tarrer, and that's enormously important because there, for the first time, we have the articulation of the principle that the Convention is a living instrument which must be interpreted in the light of present-day conditions under the ideas prevailing in democratic states today. Now, the outcome in Tarrer is pretty unsurprising. This was a teenager who was held by two police officers while he was struck on the buttocks by a third police officer. That strikes me as degrading both to the teenager and as much, if not more so, to the three police officers who are holding him or punishing him. The problem with Tarrer is, I emphasise not the outcome, but the beginning of the court's self-assumed ability to make up convention interpretation as it goes along. My argument is simply that it's wrong to have a set of arrangements whereby in private life, national law or international law, the X that is freely agreed between parties can be transformed into Y without the agreement of the same parties or without those parties having any effective power to do anything about that. In 2014, the distinguished German jurist Bernd Wouters published a book whose title translated is The Secret Revolution from the Rule of Law to the Rule of Judges, Die heimliche Revolution vom Rechtsstaat zum Richterstaat. Although the book is short, the central thesis, based on legal developments in Germany, is implied effectively in the title. There has been an increase, he thinks, in judicial power at the expense of constitutional balance. The rule of law is not to be equated with the rule of judges, and rule by judges, in fact, is antithetical to the rule of law. And Wouters, I think, is wrong only in describing this revolution as secret, since it is demonstrably occurring before our eyes. But that rule by judges is not desirable is no new idea, and it need not be held or associated with any fixed position on the political spectrum. The French phrase, gouvernement des juges, is not the recent coinage of a social conservative. The phrase formed part of the title of a work by the French comparative lawyer Edouard Lambert, Le gouvernement des juges et la lutte contre la législation sociale aux États-Unis, published in 1921. And Lambert's work studied the then contemporary jurisprudence of the US Supreme Court, culminating in famously or infamously in Lochner against New York, a jurisprudence which evinced hostility towards socially progressive legislation, at least in the coinage of those days, and which, in Lambert's view, involved the court putting itself improperly in the place of the legislature. And many, many years after Tarrer, its effect was summarized by Judge Pinto de Albuquerque in his partly dissenting opinion in Muzic against Croatia. And he said it was in the seminal case of Tarrer that the court for the very first time used the leitmotif of the Convention as a living instrument, whose interpretation has to take account of evolving norms of national and international law, deeply entrenched in American and Canadian constitutional law since the early 20th century. This interpretation technique was introduced in European human rights law in 1978. And as one commentator on the Convention has observed, in one sense, such a dynamic and evolutive approach is not interpretation at all, it amounts to judicial lawmaking. And this is quite a widespread view because despite being, in her own words, a supporter of the Convention and the work of the Strasbourg Court, Baroness Hale of Richmond, former president of the Supreme Court, has pointed out that limits to an evolutive interpretation of the Convention, and I quote, are not set by the literal meaning of the words used. They are not set by the intention of the drafters, whether actual or presumed. They are not even set by what the drafters definitely did not intend. And to go back to the United States and in the context of the constitution of that state, the famous contrarian literary scholar Stanley Fish argued it is incoherent to speak of a living constitution with an evolving meaning. An evolving meaning, a meaning that alters with the times, is, I have insisted, not a meaning at all, but a projection of the interpreter's desires. And again, speaking of an interpretive mandate, a fashionable phrase at one stage in the States, that would yield different results as society was said to need them, Fish said that such an interpretive mandate, were it acted upon in the name of a living constitution, would direct us not to interpret better, but to abandon interpretation altogether in favour of making the text mean what we want it to mean. The fundamental principle of international law is pacta sunt servanda. Agreements must be carried out. And the rule of pacta sunt servanda is not just a general principle of international law, it indeed constitutes the very cornerstone of the whole body of international law. And the living instrument doctrine is capable of transforming the content of the international agreement. It is no longer the same pactum that is servandum. This is not a plea for the ossification of international treaties. If these no longer meet their stated purposes or otherwise require to be amended, then let them be amended, but by the states who alone can legitimately do so, not under the cover of shape-shifting interpretation, that while it may be convenient or may be regarded as desirable in terms of result, is policy making in the guise of judicial determination. And one of the early UK judges on the Strasbourg court, Sir Gerald Fitzmaurice, he observed in his partly dissenting opinion in Golder, the point being not whether the Convention ought to provide for such a right, in that case access to the court, but whether it actually does. And this is something that affects the whole question of what is legitimate by way of the interpretation of an international law treaty, while keeping within the bounds of a genuinely interpretive process and not trespassing on the area of what may border on judicial legislation. In short, Tara is the Strasbourg Court's declaration of independence from the text of the Convention, and this is a rebellion against the Convention which should be emphatically suppressed. Now, I'm going to give simply two examples of the Court treating the Convention text as its plaything and simply rewriting the Convention to have it read as a particular formation of the Court thinks it ought to read, rather than how it was designed to read and objectively does read. And hugely relieved that Lord Sumption did not refer to these cases, so I'm not engaging in vain repetition. The first is McCann against the United Kingdom, and in that case, by 10 judicial votes to 9, the Strasbourg Court held that there had been a violation of the Article 2 rights of the applicants. And in McCann, for the first time, the Court held that Article 2 requires by implication, note that, by implication, that there should be some form of effective official investigation when individuals have been killed as a result of the use of force by inter alia agents of the state. And if I can be permitted to quote myself, in a paper published in 2020 by Policy Exchange, I referred to this conversation I had with a senior official of the registry in Strasbourg, and the judgment in McCann was described to me by this senior official as the equivalent of an additional protocol to the Convention. Think about that for a moment, the equivalent of an additional protocol to the Convention. And when I jocosely taxed the author of the statement with a somewhat astonishing candour, she said, but I think it's a very good development. And my rejoinder, weak as it was, well, it may or may not be, but it was for the states to decide, not the court. Second example is Scopola against Italy, number 2. It's a 2009 decision, and the Grand Chamber, having previously acknowledged, and rightly acknowledged, that Article 15 of the ICCPR provided for a lex meteor, that someone should have the benefit of a subsequent lesser sentence. Article 7 of the Convention did not do so, and there were a string of cases in which the old Commission and the Court had approached Article 7 that way. But nonetheless, the court went on to say, Article 7.1 guarantees not only the principle of non-retrospectiveness of more stringent criminal laws, but also, and implicitly, note that, implicitly, the principle of retrospectiveness of the more lenient criminal law. And put bluntly, this is simply another example of the court making it up as it goes along. Now, the next stage in this talk really is divided into two. So I'm going to look at some potential minor reforms. Now, they would be regarded, I think, perhaps only by we, as some of us at least, as relatively minor reforms, regarded perhaps by the Strasbourg equipe as dramatic and unwelcome, but wait until you see what I come to in the final stretch. So while I do make, and we'll come to that in a moment, arguments for some significant reforms, I want to look at before discussing some minor potential reforms, the argument that the reform process is underway. And we heard from Gaëtan the process that Strasbourg has heavily engaged certain NGOs in. And indeed, energetic supporters of the court, as presently constituted and doing what it's currently doing, often point to a process of reform which is said to be underway. And if you go onto the court's website, you'll see there is a separate section on reform of the court. And they point in particular currently to Protocol 15, and this entered into force on August 2021, but was signed as long ago as June 2013. So I suppose one should reconcile oneself to the fact that reform can occur, but it's not being done at all quickly. Now, in fact, Protocol 15 really doesn't do very much that confers advantage to those outside the court. There is a new recital to the preamble of the Convention, and that refers to the principle of subsidiarity. But I've yet to see what difference that makes in the case law. Article 4 of Protocol 15 changes the time limit for applying to the Strasbourg Court from 6 months to 4 months. That obviously benefits the court because the court has, simply in terms of the physical task of processing applications, an unenviable paper burden, electronic burden, and therefore that benefits the court, but doesn't particularly benefit potential litigants who will inevitably fall foul of the more stringent time limit. And then a tweak that was required to occur in whether there was actually a real detriment experienced by an applicant that such a person had to go through the domestic court system was removed. So I conclude, and I invite you to conclude, that any reform that commends itself to the Strasbourg Court in its existing form is unlikely to really be worthy of the name. Can the institutional culture of the court be reformed? Now, the term of appointment of a judge of the Strasbourg Court is 9 years. The registry staff, including the registrar, the deputy registrar, and the jurisconsult, are in practice permanent appointments, that is, appointments until retirement. And it's well known, I think, by observers of the Strasbourg Court that the institutional memory of the court, indeed much more besides, is lodged in the registry and not in the judges who are gone after 9 years. The judgments of the Strasbourg Court are significantly shaped by the registry. I recall one UK member of registry staff recounting to me how a retired judge of the court had, when speaking about a recent judgment of the court, said to her, "I can always tell when it's one of your judgments." Now, no one taking part in the conversation thought it in the least odd that a judgment of the Strasbourg Court should be largely and recognisably the work of a member of the registry and not one of the judges or a panel of the judges of the court. So I propose that Articles 21 to 23 of the Convention should be amended to provide that judges should be appointed until retirement at 75. There should be no limit to the number of years a judge may serve before that date. And a judge in respect of a member state of the Council of Europe should be appointed simply by the government of that state. So We've heard from Gaetan there's a move to actually weaken the role of national governments. I think the role of national governments in appointment to the Strasbourg Court should be strengthened. I'm not come to a small point, but I think an important point. The Office of Jurisconsult, created by Rule 18b(3), and that's a rule inserted only in 2014, should be abolished. And this office exists, and I quote, for the purposes of ensuring the quality and consistency of the court's case law. Now, it's, I think, the function of the judges of the court, individually and collectively, to ensure the quality of the court's judgments. Judges should not be appointed who cannot themselves discharge this function, but it's wrong in principle to give an official of the court a responsibility which ought only to be discharged by judges. And as for consistency, to the extent that it is a judicial virtue, very often it is, occasionally it's not, then that's a judicial responsibility also. And no doubt the suspicion exists among those who observe the Strasbourg comings and goings of some form of sub-Faustian pact by which judges are able to enjoy an agreeably leisured existence in Strasbourg while judicial work is in essence discharged in large measure by the registry. And I suggest that those who are appointed to act as judges and those who are paid to act as judges should act as judges, and that the institutional memory of the court, which will of course change colour over time, should be primarily, overwhelmingly, the property of the Strasbourg judiciary and not the registry. So we then turn to more significant reform of the Convention, and I have three proposals. The first and second can coexist each with the other, as can the second and third, but there will be no need for the first reform if the third is put in place. So, insert the words subject to Article X at the beginning of Article 46 of the Convention, and this then is Reform 1. So, within 1 month of a final judgment in a case under Article 34, in which it is a party, a high contracting party may lodge an interpretive declaration with the Committee of Ministers and the Registry of the Court. An interpretive declaration may indicate that the high contracting party does not accept in whole or in part the interpretation or application of the Convention given by the Court in that case. Within 3 months of the lodgement of an interpretive declaration under paragraph 1, the Committee of Ministers may decide by unanimous vote by high contracting parties, other than the high contracting party lodging the interpretive declaration, to reject it, whereupon the declaration is without effect. If the Committee of Ministers does not reject the interpretive declaration, the obligations of the high contracting party under the Convention are modified by the declaration and may, if the declaration so provides, be retrospectively modified. And then finally, nothing in this article removes the obligation of a high contracting party to pay damages and costs. So this suggestion relates fundamentally to the future shape of the Convention. So this protocol or article introduced via protocol would re-establish the primacy of sovereign states as the creators of international obligations. States would be able to enter interpretive declarations within 1 month of final judgments, and they could reject the interpretations of the ECHR proposed by the Court. The interpretive declarations would be effective as respects the state entering them. There might indeed be provision for other states to join, but they would not free the state from any monetary obligations, damages and costs contained in the judgment. Issues for debate, for tweaking, include the extent to which the new judgment, relying on an old but objectionable interpretation of the Convention, could be subjected to the protocol process. That's why there's the reference to retrospectively modified. So if, for example, let's take prisoner voting, there is another prisoner voting case which, contrary to the pilot judgment procedure, ends up in Strasbourg. The UK could enter an interpretive declaration with respect to the first protocol and its extension to voting rights of sentenced prisoners. Again, that text suggests that it should be unanimity apart from the high contracting party affected, but one could debate whether it should be a heavily weighted majority. But it does mean that where states have agreed X, no international court can come along and tell them that X means Z. If states want to agree that there should be an enforceable right, for example, fashionable in terms of the legacy debate in Northern Ireland, a right to truth in the Convention, then that's fine. But one couldn't, without such a protocol, it couldn't be foisted on them by the Strasbourg Court. So the issue is not, we're not at all opposed to interpretation, but bluntly, it isn't interpretation to play Haydn when the concert programme and the score call for Mozart. Not the least important aspect of this proposed reform is the role that it gives to the Committee of Ministers. In the Statute of the Council of Europe, the Committee of Ministers is by some distance the most important institution. Now, at least in relation to the court, it finds itself playing the role of bailiff in relation to judgments of the court, a bailiff that can be worn out, as we've seen in relation to prisoner voting, but a bailiff that normally does the court's bidding. And I think that the outer limits of what are acceptable European human rights standards should be set by the Council of Ministers and not the Court. It'll be for individual states of the Council of Europe under this proposed reform to respond doctrinally to judgments of the Strasbourg Court, and it will be for the Committee of Ministers to decide if the doctrinal response by states exceeds a European consensus. Okay, Reform 2. The living instrument doctrine should be formally repudiated and a regime of interpretive restraint introduced. This can be done neatly, I think, by a protocol that adopts with modifications the language that the Strasbourg Court itself uses in Johnson and Ireland and Article 31 of the Vienna Convention. There's Article 31 of the Convention. And one can see really how the living instrument doctrine is utterly at variance with the language of Article 31. And helpful sometimes just to sort of recollect what was an earlier era or perhaps an aberration in the court's doctrine. Because Johnson, which was about a claim that Article 12 of the Convention, which provides for a right to marry, also contained a right to divorce. And the problem was the then Irish constitutional ban on the granting of divorce decrees. Now, if that case were to come before the Strasbourg Court and there were still to be the constitutional ban on divorce, one can imagine that this would be simply chewed up and spat out by the Strasbourg Court. But then they said the court cannot, by means of an evolutive interpretation, derive from these instruments a right that was not included therein at the outset. This is particularly so here where the omission was deliberate. So that case has really quite an antiquated flavour by reason of that respect, the deference indeed shown to the constitutional tradition of a high contracting party. So here we are. This is the second. So the court shall interpret the convention strictly in accordance with the natural meaning of its terms when these were first agreed. Without prejudice to the generality of its duty in paragraph 1, the court shall not, by means of an evolutive interpretation or otherwise, derive from any article of the convention a right or meaning that was not included therein when that article was first agreed. And there is a typo in 3, which you've all instantly spotted. No final decision of the court, whenever given, shall be followed or otherwise regarded as correct by the court if to follow or otherwise regard that decision as correct would conflict with the duty in paragraph 1. Now, the reason why 3 is there, because the court isn't really known for any slavish adherence to precedents, but if such a reform were put into place without it, one might find that the court might develop an enormous attachment to its previous decisions. So paragraph 3 is designed to prevent any new slavish adherence to precedent by insisting that past judgments, which may indeed have gone far beyond any orthodox interpretation of the Convention, are, so far as relevant to any current case before the court, they must yield before the duty in paragraph 1. Not much time left. Reform 3. The right of individual petition. This is a very fundamental reform. The right of individual petition should be replaced by conferring on the highest national courts of member states the discretion to refer questions to the European Court of Human Rights for advisory opinions. And at present, we have both the right of individual petition under Article 34 and the regime of advisory opinions under Protocol 16. It's an optional protocol wherever that applies. And what I ask rhetorically is, would it not be preferable for the Strasbourg Court to persuade by the quality of its analysis of the Convention, by way of being a persuasive interlocutor, rather than enforce its sometimes eccentric interpretations on the member states of the Council of Europe? And this is a fundamental reform of a structural provision of the Convention. The right of individual petition would no longer be possible, but the Court would in future only give advisory opinions on the interpretation of the Convention and its protocols on questions referred to it from designated national courts. The obligation of the high contracting parties would no longer be, as it is now, to abide by a final judgment of the Court, but instead their national courts would give due consideration to the Court's advisory opinion, and of course the Council of Ministers would consider the national response. And as I suggested, this reform draws on optional Protocol 16, which may be thought itself to be a development of the more limited provision for advisory opinions in Article 47 of the Convention. It makes provision for advisory opinions and currently enables the highest courts and tribunals of a high contracting party to request the courts to give advisory opinions on questions of principle relating to the interpretation or application of the rights and freedoms contained in the Convention, and that request can only be made in the context of a currently pending litigation before the relevant national court. And under Protocol 16 at present, it's for a panel of 5 judges to determine whether the court will give an advisory opinion, and if it makes it through the panel, then it's the Grand Chamber that gives the advisory opinion. It must be reasoned. There is the same provision for dissenting and concurring judgments as there is now for judgments with respect to Article 34 applications. And again, even though it's implicit, one might think in the context of an advisory opinion, Article 5 of Protocol 16 makes it clear, perhaps unnecessarily, advisory opinions shall not be binding. And it seems to me that although the Strasbourg Court very often speaks about dialogue with national courts, this dialogue, if that can be properly so called, is at present inevitably skewed towards the authority of the Strasbourg Court. A judgment of the Strasbourg Court against the UK on topic X, of course, binds the UK only by virtue of Article 46.1. It doesn't bind the other high contracting parties, but none of them are likely to fare better on that issue when it comes before the Strasbourg Court. And a final judgment of the Strasbourg Court is at present binding, not by virtue of the quality of its analysis or reasoning, but simply only by virtue of Article 46.1. A shift to advisory opinions would, I suggest, incentivise better reasoning and analysis and promote a more obviously dialogic relationship between the court and the courts of the high contracting parties. And of course, one can see perhaps why the Strasbourg Court is so plainly eager to position itself as a partner in dialogue. From Plato onwards, the dialogue or conversation has often been one of the ways in which we in the West have attempted to get at the truth. And the court would perhaps rather be thought of as a respectful partner in dialogue than a stern lawgiver wagging its collective finger at wayward contracting parties. Of course, pausing to note that the highest national courts do not, in my experience, see themselves as partners necessarily in dialogue with the courts from which appeals come. If the Strasbourg Court wishes to improve dialogue with national courts, then it could hardly object, one might think, to a system which gives to the Strasbourg Court's judgments only such force as the strength of the reasoning analysis in those judgments. I can't resist, in terms of coming to a conclusion, without a reference to LB against Hungary. It's a decision of the Grand Chamber of the Strasbourg Court given on the 9th of March this year. And the Strasbourg Court finds a violation of Article 8 from the publication of the personal data of a significant tax defaulter in circumstances which suggest that the court itself behaved with some procedural unfairness towards the member state. And I commend the dissenting judgment of the Polish and Hungarian judges, and otherwise improperly by taking upon itself to evaluate the quality of the parliamentary consideration of the impugned measure without having drawn its concerns during the litigation process to the attention of the member state. And essentially, the outcome in that case turns on the court's assessment of the quality of the parliamentary consideration. And again, I couldn't help being struck by the various observations about elites. And it really is not, it seems to me, the function of an international court to pronounce on the quality of debate that takes place in national parliaments. But wouldn't it be interesting if the acceptability of the court's judgments were in future to depend upon the government assessment of the quality of the court's reasoning? Thank you very much.
Thank you very much, Professor Larkin, and it is now time for questions.
If I thought that there was much prospect of any of your proposed reforms being accepted, I would be in favour of remaining in the convention until it happened. Do you think that there's any prospect of their being accepted?
Well, ultimately, if I were a betting person, which I'm not, I wouldn't stake much money on it. But I think the point which I made and would continue to make in support of quite significant structural reforms would be the member state that attempts to achieve those reforms cannot really be blamed if, having attempted them unsuccessfully, it then says, well, that's it, we're off. So it's at the very least, it's a better platform for denunciation.
Thank you very much for the excellent speech, and I have a question regarding the interpretation of the courts, and how does this interpretation differed in the 2000s and in the 2010 years, both regarding international courts and regarding the courts of Northern Ireland? What were the trends regarding the differences in interpretation?
Well, Conor touched a bit on this, and just as I think there are very few people who will disagree with anything really that's in the text of the first part of the convention, there's also the issue that in a process that can be roughly equated to the so-called gold plating of EU secondary legislation that was said to occur within the UK, sometimes one found that national courts applying Section 6 of the Human Rights Act in the UK often went further than what Strasbourg itself would be expected to do. And there's a whole debate within the UK, the so-called Ulla doctrine, the retreat from Ulla, and a former colleague of Lord Sumption's, Lord Brown. Did your tenure overlap with Lord Brown? Yes. That's what I thought. And he made the point, which I think is well nigh unanswerable, that there's a structural unfairness in a domestic court being adventurous in terms of its application of the convention, because the member state, if unsatisfied and if wronged by that outcome, cannot itself go to Strasbourg to have the matter put right, whereas if the national court is too niggardly in its interpretation or application of the convention, then the individual citizen or group can, of course, take the case to Strasbourg.
Thank you also very much for this very thought-provoking presentation. I had a question concerning your minor reforms, perhaps, as far as concerned to increasing the government's influence on the appointment process of the judges, because there will be certainly a charge against this proposal which argues that, well, that contributes to the politicization of the court. So what will be your reply to that?
Well, I have actually really great difficulty in grappling with that, because it seems to me there's absolutely nothing wrong with the executive, and I'm speaking here in a national setting, with the executive having an absolute right to appoint judges. What matters is the quality of the judges they appoint and what the judges do after they're appointed. And so in Ireland, currently, it's the responsibility of the executive to appoint judges. They have a slate of names that are put up to them by Judicial Appointments Commission. In the UK, it used to be the appointment by the executive. Now it's increasing, largely with the exception, I think, of the Court of Appeal, it's appointments by the Judicial Appointments Commission. In the United States, of course, it's appointment by the President, following confirmation by the Senate. And again, you know, on this side of the Atlantic, I suppose, we perhaps quake a little at some of the more boisterous Senate confirmation hearings. But it seems to me there's absolutely nothing wrong with the executive taking upon itself to appoint judges. But it seems to me there's something profoundly wrong with judges appointing judges, or quangos appointing judges, because the members of the executive are politically accountable. So essentially someone can stand up in Parliament and say, "Oi, why did you appoint that bum judge so-and-so?" You can't do that with respect to a Judicial Appointments Commission. So it seems to me that the notion of the politicisation of the appointment process is entirely misplaced. And it suggests, and again, this perhaps piggybacks on a theme that Lord Sumption has written about, it's as if there's something wrong with politics. Naturally, Republicans, to use the US example, are going to tend to appoint judges who view the world in a particular way. Democrats will appoint, as it were, judges who they think are sympathetic to their view of the world. But if you take someone like, and I mention this because he's published, there has been published an enormous oral history of Guido Calabresi, who was a very distinguished law professor, but also a very distinguished member of the Federal Court of Appeals. And plainly, I mean, he was a Clinton appointment, and Clinton thought he was a good guy from within Clinton's worldview, but he was a distinguished judge. I wouldn't agree with necessarily all of his decisions, and so what? He was a judge of integrity, a judge of consummate intellectual ability. Reagan or Trump mightn't have appointed him, but what's wrong with that?
Can I suggest what might be wrong?
Yeah.
That sort of system works fine if there is a convention about how this appointment process is done. The only avowed Marxist who has ever sat in the UK House.
Magnificent appointment.
Well, absolutely. But it's not going to work unless you are bound by a range of conditions which recent presidents of the United States have not found it necessary to observe.
Well, of course, I think that the riposte is that in the States it doesn't particularly matter because you have the Senate as the counterweighing factor. Yeah. Well, I'm not sure that does. Obviously, we do look with horror at some of the more boisterous exchanges, but it seems to me that and it shows part of the problem with when we interfere with the system that worked perfectly well, as the UK system did, we lose something that may not easily be recovered because, and can it be imagined that there would be the same intellectual generosity and concern for the common good as Quinton Hogg displayed by appointing, as he now is, Sir Stephen Sedley? But there should be, and there was, and there's no reason why the British political tradition doesn't have the resources to do that again.
I wish you were right.
John, that was great, and I agree with, I think, 95% of the reform. One quibble, when you mentioned the potential reforms to the jurisconsult and the registrar, would we need to look carefully at the advantages and disadvantages of tenure up until 70, particularly if you think that some countries appoint judges in their 40s or 50s? That's a very long time, and I think a priori you can make arguments for and against, but if you dug into it, there's probably costs in that a judge there for that long will become very comfortable. They'll build up a legacy in their own mind. They'll maybe find it harder to course correct, or they'll be more concerned about what they leave behind. But there are advantages, institutional memory, you don't want too rapid turnover, but I wonder if we need to do a lot of digging to see how different systems have fared with longer, shorter term limits.
Yeah. Well, again, I mean, I think that's an entirely obviously reasonable response. But the point you make about age could, of course, equally apply to domestic judges, so that the same issue would doubtless arise. And indeed, there is a sense perhaps that, I think for all kinds of reasons, it may be such a notion as appointing someone too early to the High Court, for example. But it doesn't seem to give rise to problem. The problem that previously existed was that judges who clung to their places like wax when they were manifestly incapable of discharging their functions. So, bearing in mind that, yes, of course, this is designed to deal with the problem of the over-powerful registry, but one would have to consider that. But let me say parenthetically, of course, is there a more splendid title for any law job on the planet than jurisconsult? Yeah. Oh.
Many thanks for sharing this project, interesting project. I have two questions. First, the cost of the European human rights justice. I think the wages of European judges, notably compared to the national wages, are incredible. So, of course, the system was based on the wages of lords in the UK, just to make the profession attractive. But when you take a look at the Romanian or the Moldavian judge, come on, it's such a step, and the cost of this European justice is massive regarding what it delivers, or it depends on what criteria you take into account to evaluate the performance of the court. So, and second question is about transparency. So I agree with you that national states could monitor the activities of the court and so forth through which mechanism? A monitoring system or a national monitoring institution or something like that objectivize the issue of transparency and so forth. So that was my question.
Okay, well, the discussions of salary are always very, very delicate. Well, I did refer to the suspicion of a sub-Faustian pact, and there's no doubt that it comes from certain countries with that salary. One will be rich beyond the dreams of avarice by comparison with one's compatriots. But I don't know. Certainly, the salary will be regarded as mid-level in relation to the UK judiciary, and I can't imagine it would be very far from the median in terms of France and Germany. And I think there are important reasons of principle why there really couldn't be a differentiated salary structure. Well, there could be, but I think it would give rise to many more problems than it would solve. And I also think that the judicial salaries are a fairly modest part of the overall court bill. In relation to, I'm not quite sure I get the point in relation to national monitoring. What I'm suggesting is that the reform that would give the Committee of Ministers a decisive role in whether or not to accept an interpretive declaration obviously involves them thinking more themselves about what the relevant human rights standards are. And one of the larger problems is that, and maybe this is one of the reasons why international courts have this function, that it's a way in which an issue can be, to use the inelegant term often employed in the UK, long-fingered, so it can be put off, put at arm's length, and domestic courts don't really have to deal with it too much. But I think when one looks at the statute of the Council of Europe, it's quite clear that the Committee of Ministers is designed to be the institution within the Council of Europe of the greatest importance. And I think it's a political entity, obviously, and I think its primacy should be restored.
One last question.
Thanks for that speech. I just have a question about reform, too, and how that would work with the proportionality doctrine, because it seems to me that in the proportionality test, and specifically the balancing test at the end, that there's a kind of living instrumentness to that already built in, because the court's not specifically saying there is a right or there's not a right. It's saying that in the context of this alleged infringement of a right, there has to be a pressing justification, and then that automatically brings in thoughts of the opinions of the current day.
Well, again, I have a minor obsession with the Strasbourg proportionality test, because it strikes me that, number one, it's often been overcomplicated when it's been domestically restated sometimes, but in the last analysis, it seems to resolve to me to a kind of Strasbourg sniff test. Do we really dislike this? And if they really dislike it, then it's disproportionate. And that's where it falls down. But it's interesting, and I think sometimes, for example, in the Heathrow noise case, in the Chamber judgment, there was much evaluation of the quality of parliamentary scrutiny. In Hirst, the prisoner voting case, when it came up for the court, again, the decision appeared to turn, as in the Hungarian tax defaulter case, on the quality of the parliamentary judgment. But that didn't work, because then when the UK intervened in a later Italian case and said, oh, we've debated this extensively now, because, well, that doesn't matter. We still don't like it. So I think it's preference, and therefore, insofar as it inevitably involves an application or an interpretation, and that's why the writer meaning that was shall interpret followed, otherwise regarded as correct. Maybe actually one should, to make sure one could, let's say for example, one could, I suppose, now this was the difficulty with drafting, that one might have to put interpret and apply, because very often the final stage of the proportionality test isn't so much interpretation as application.
Just a quick side, which might be that reform. I mean, the Strasbourg court, in so many cases, just gives up on determining the scope of Article 8, for example. They just assume. There was a case in Stubing in Austria, which was a case about incestuous relations.
Oh, yes.
And the court just said, we'll assume, yeah, it's privacy, Article 8, without thinking, well, why would the scope be that far? Yeah. And if you really take the scoping issue seriously by interpretation, you really don't go to proportionality. You would.
I mean, a rigid scope means less problems. I mean, fewer problems.
If you take Article 8 seriously in its term, reason, intent, then very few issues, comparative to now, would get to proportionality. Yeah. You only go to proportionality under the court's precedent if the right is prima facie engaged, which authoritative interpretation it often wouldn't be when it currently is.
Yeah. Now, in fairness, I should say that in one of these seminars, a judge, I can't remember which state he was judged in respect of, pointed out that Article 14 was increasingly interpreted as if it had a freestanding existence. Obviously, yes, there's the ambit test, but there are very few, where there's a will, there's a way, so there are very few of the qualified rights where one can't find, oh, that's in the ambit. And again, that was one of the problems. I mean, terror is the start of a dreadful trend, but Marx, in relation to Article 14, is the start of another.